What's up, guys? So we're talking about Rittenhouse. Now, I made a couple of videos about this whole situation when it actually went down. They've since been removed from YouTube. I'm not sure if I ever uploaded them to my BitChute. They may or may not be there, but they're gone. And what we did in those videos was we went through the video evidence because the video evidence was available back then when this happened. And something that's very frustrating about this whole situation is the video evidence has been available the entire time. Now, interestingly enough, they've got this new enhanced video evidence that came from drone footage that the feds were flying drones over top of the riots, which we didn't know that at the time. You learn something new every day, right? So there's even new enhanced drone footage of these instances, and they all back exactly what Rittenhouse is saying, that he was acting in self-defense. Now, I'm not going to get into the legalese. We're not going to get into the semantics of the case. This isn't that kind of channel, but we do cover circuses, right? And this is a circus. It is turned into an utter circus. And how has that happened? Well, the prosecution's case has gone so horribly that they're trying to throw the case. They're trying to shoot for a mistrial. They don't want the jury to rule because they know it's not going to go for them. So they're trying to get a mistrial. Now, they might mess around and find out, and the judge give them a mistrial without the ability to re-prosecute at the rate that they're going now. I'm not sure if the judge is going to allow this case to go to the jury or if he's just going to declare mistrial outright, because the judge is fed up. And all that's left for the people who are attacking Kyle Rittenhouse and the people in the media who lied about him and the politicians who have pushed for his incarceration is their same old, same old. And that's character assassination, misrepresentation of the facts, obfuscation and hiding of the facts. I mean, you're talking about a guy here who is on trial for killing a child molester and a habitual woman beater. And the guy that he shot in the arm, who is the star witness for the prosecution, has an instance of operating a firearm and being intoxicated, which is what he was doing whenever he got shot. And so it's already a very difficult case for the prosecution on the facts. Now, you wouldn't know that watching some of these news channels. You just wouldn't know that. But it is. It's a very difficult case. And then you add to that the prosecutor, who obviously has political aspirations, those are in the toilet, by the way, but he did, overcharged, going for murder one. So you have this culmination of events where there's nothing left but character assassination and their same old dirty tricks that they used in the Roger Stone trial. Now, in the Roger Stone trial, you got to see a lot of firsts. The feds overreaching, calling the CNN before their raid, jury intimidation by that side of the political sphere, and that's what they did, outright jury intimidation. They doxed those jurors and they threatened them, and they're attempting to do that with the Rittenhouse jurors because this is their final play. One of their final plays is to intimidate the jury into being terrified, ruling the way that it should be obviously ruled. So you have people who have been outside videotaping the jurors so that they can try to look them up with reverse image searches and find out who these jurors are. The judge already spoke about that. So all of this is happening because the trial is essentially over. The prosecution presented their case and they literally set fire to their own case and watched it burn. And so all you're seeing are all these last-ditch efforts of very desperate people who really have to continue to push this narrative. And when you look at like the Nicholas Sandmann incident, the media entities and the political entities that bought fully into that and pushed that outright lie, that untrue narrative, they rode that thing all the way to the end. With Jussie Smollett, with Juicy Smollett, Jussie Smollett, the people in the media who told the lies and the politicians who commented on them, they rode those lies all the way. So it's not like we should expect the narrative to change in the corporate media about the Rittenhouse case. It's not going to, but we are going to see it escalate and become more hyperbolic because, like a caged animal, they're running out of options. And so Kyle Rittenhouse did his testimony, and for this young kid, he's so poised. I've never seen somebody on the stand quite like him, and it's pretty bizarre that this kid ended up in this situation. But it's become hyper politicized, of course, like everything is in this day and age, and of course like everything that was happening during that time period, because America was in a different kind of psychosis at that time, where BLM was rioting, and hundreds of millions of dollars of damage were being spread out throughout the country. Businesses and homes were being burned. Dozens of murders were committed, and next to nobody went to jail. So we were in a different kind of psychosis back then. And now looking back on it, listening to this trial, you can see just how bad the insanity had been whipped up, because this prosecutor overshot. And when he did, the video evidence was already on the internet. You could already see for yourself. But in the face of this horrible week for the prosecution, and the fact that it's become almost a sure thing that Rittenhouse is not going to be charged with the worst crimes in this docket, I was interested how the mainstream corporate media was going to report this, how the other side was going to report on this. And what I found was outright disturbing. The level of propaganda that is going on in the corporate media is really out of control. I guess I've kind of missed it because I just turned it off a long time ago. And short of show research and a little bit of Tucker Carlson, I don't watch the corporate media anymore. And wow, these people are propagandists. They're actors. They're literally actors. It's pretty wild. But I mean, here you're looking at the prosecutors in this case right here, right after the one living witness testified that Kyle Rittenhouse absolutely did not fire his firearm towards him until he had pointed his loaded handgun at Kyle Rittenhouse. It's literally admitted that right on the stand. During the cross-examination, this is a prosecution's witness, though. The defense team has not even presented their case. Keep that in mind. This is these people's witness that has this guy's hand on his head like, oh my God, how did I end up in this? How did I end up attached to this guy? And this guy is the guy in the glasses right there. He's the prosecutor. A complete tool bag. He's a tool bag, you guys. It is amazing to see how people like him end up in the positions that he's in. And the answer to that is he's a yes man. He toes the line. When everybody told him to charge Kyle Rittenhouse with murder one, he did it. Because he's never known standing up for himself in his entire weaselly little life. So I want to go over this MSNBC spot on the Rittenhouse trial and how it's gone this past week. And I'm going to interrupt a little bit, but just listen, knowing the facts of the case, just listen to how they are presented in this spot. It is, to call it a frame job, to talk about framing in this context is not even doing it justice. It's just outright propaganda. It's so bizarre. But anyways, let's get into it.
Jurors heard from the lone survivor, Gage Grosskreutz.
They're trying to call this guy the lone survivor. They're actually trying to make that happen.
Who was training to become an EMT and was providing care to anyone who needed it. That deadly night in Kenosha, Grosskreutz came.
So he's presented to us as a guy who was training to become an EMT and a guy who says that he was out there to provide aid to whoever needed it. Okay. No mention of his criminal record. No mention of the fact that he had a loaded firearm. No mention of the fact that he pointed the firearm at this kid.
Across Rittenhouse after he had shot and killed Joseph Rosenbaum.
Oh, I forgot that I had put these little things in here. I was making a different video. These are just little quick blurbs about who these people are that he shot. I'll just let that sit there for a second. Okay.
And was about to kill Anthony Huber.
He was choking them from what I read. Likes to choke women.
Grosskreutz acknowledged that he was armed with a pistol, but says his hands were raised when he was shot by Rittenhouse.
Oh, does he? Does he say that? Because what you're about to hear is he says that he's shot by Rittenhouse after he points the gun at Rittenhouse. So how could he have his hands up, hands plural, and be pointing a gun at Kyle Rittenhouse? It's an outright lie. It's an outright lie.
the pistol, but says his hands were raised when he was shot by Rittenhouse.
Here's the little blurb about this guy. This kind of sums the whole thing up, talking about the people who were shot by Kyle Rittenhouse. Rosenbaum was a registered sex offender who was out on bond for a domestic abuse battery accusation and was caught on video acting aggressive earlier that night. Huber was a felon convicted in a strangulation case who was recently accused of domestic abuse. Grosskreutz was convicted of a crime for the use of a firearm while intoxicated and was armed with a handgun when shot. You can read their criminal records in full, and you guys know where all of my sources are always at, below the pinned comment. So if you just click on the pinned comment like you want to reply to it, then the source will be down there for this article. Not mentioned in here is that Rosenbaum was actually just released from a mental institution earlier that day and then took off straight to the BLM riots. So these are the people he shot, okay? None of this information, of course, is ever going to come across MSNBC's desk. And a matter of fact, they're going to paint this guy like he's the lone survivor, some kind of amazing person, right? He was an EMT out there to provide aid with a loaded gun, pointing it at people. Okay, I would expect them to provide video footage of him saying both of my hands were up when I was shot, right?
I thought that the defendant was an active shooter. And like I had mentioned earlier, anytime you add a firearm into the equation, like I said, the stakes are so much higher.
He thought he was an active shooter running away from him. So you have an active shooter, supposedly. This guy thinks that this guy's an active shooter. He was running away.
Somebody potentially being seriously injured or being killed.
What was going through your mind at this particular moment?
That I was going to die.
So that is the spot that they choose to play. Now, I want you to hear him take this deep breath in when it cuts back to him. This is acting.
He then testified that after...
He then testified, because it was such chilling footage.
Rittenhouse killed Huber, he trained his weapon on the witness and reloaded. Not accepting his gesture of surrender, Grosskreutz then thought to disarm the shooter.
I was never trying to kill the defendant. That was never something that I was trying to do. In that moment, I was trying to preserve my own life.
He was trying to preserve his own life, chasing after Kyle Rittenhouse. And his intent was never to kill him when he was pointing the handgun at Kyle Rittenhouse, which shouldn't be a surprise. Because, right, this guy, you shouldn't expect him to know that you don't point a loaded firearm at something you don't intend to kill. You shouldn't expect him to have that basic firearms knowledge, right?
But doing so while also taking the life of another is not something that I'm capable or comfortable in doing.
So that's what they choose to play from this witness testimony.
Grosskreutz was ultimately shot, describing to the court that Rittenhouse vaporized his arm, his word,
Vaporized his arm, his word. Now, why does it have to be his word? Because otherwise, the news anchor would be using hyperbolic language, right? So his arm wasn't vaporized. He got shot in the arm because he was using that arm to point a loaded handgun at somebody. And because the anchor can't make a claim and use speech like that, he gets around it. And he can use this emotionally charged word because he says what the witness said. It was vaporized, not my words.
Way much of the bicep. Jurors looked away as the state showed the moment Rittenhouse shot Grosskreutz. At one point, according to pool notes, a juror nodded in agreement as the judge instructed the jury to disregard Grosskreuz's description of the shooting of a protester as, quote, murder.
The way that this anchor chooses to close this out, and at that exact moment, that would have been the moment to tell his audience that the witness said he did not get shot until he pointed the firearm at Kyle Rittenhouse. And instead, he says that.
A juror nodded in agreement as the judge instructed the jury to disregard Grosskreuz's description of the shooting of a protester as, quote, murder.
The protester that was shot, we went over them. So people have a lot of words for those types of men, okay? And they're not pleasant ones, okay? But the judge saying you can't call that murder because whether or not it is murder is literally up for debate in this trial. They keep trying to frame it as if the judge is acting like a racist MAGA, a Democrat appointed judge. They're literally dog whistling, hilarious because these people are always projecting, but they're literally dog whistling about this judge and about a juror because they say that it was in the pool notes that a juror nodded in agreement as the judge said you can't call the murder of that protester murder. Okay, and it leaves the MSNBC viewer feeling like the trial is tainted. And that is the framing that this entire news spot is set to create.
Joining me now is Paul Butler, former federal prosecutor and Georgetown law professor. Paul,
remember, read the title of this news spot and understand we're halfway through it and we haven't even heard from the legal expert yet. But that's what they choose to title this. Not witness in Kyle Rittenhouse trial admits he wasn't shot until he pointed loaded weapon at Kyle Rittenhouse. That's not it. It's this. It's literally a presentation of alternate reality.
Great to see you. Would love to get your reaction to Grosskretz's testimony, because I always thought that, folks like the good guy with the gun, but
I always thought that folks like the good guy with the gun. What a jerk. That is soft bigotry right there, right? Those are the idiot, smelly Walmart people like the bunny ears good guy with a gun. And this guy he's trying to frame as the good guy. Is it Kyle Rittenhouse, the 17-year-old with no criminal history and that was there to do good? Or is it these guys that he shot that I'm not even going to mention again what they are or who they are? It's a literal inversion of reality. And now comes the frame job real heavy and hard on the judge, because the key things they want their audience to walk away from with this is that the judge is compromised and the jury probably is too.
But also this judge and his actions in this case.
Jonathan, the prosecution has a tough case proving attempted murder because Mr. Grosskreutz himself was armed. He testified that he was afraid that Mr. Rittenhouse was going to kill him. On cross-examination, the defense got this witness to admit that it wasn't until he was pointing his gun at Rittenhouse that Rittenhouse fired. So that could bolster Rittenhouse's claim that he shot in self-defense because he believed that he faced a deadly threat.
So right off the rip, after 10 minutes of nonsense, you hear this Georgetown law professor finally say what actually happened and the fact that it, quote, could bolster his claim of self-defense. Could? Could? In what way could? It does, right? But you're about to hear the spin. You're going to hear how they negate this. And first, the Georgetown professor has to present it so that then the news anchor can downplay it. And you heard the news anchor say, whenever he mentioned the idea. And now watch the okie doke that the news anchor does. He's about to call it that little thing he said.
Wait, but Paul, I mean, we just heard Grosskretz's testimony where he said he thought it was an active shooter. So does that not, I mean, at a minimum, cancel out that little thing that the defense got him to say on the stand?
That little thing that the defense got him to say on the stand. Doesn't the fact that he thought Kyle Rittenhouse was an active shooter, even though that's not an accurate description of what Kyle Rittenhouse was at that moment, it is only accurate if you believe the prosecution's version of events, which is all that MSNBC in this news spot is presenting as actual reality. They're not presenting the two sides. They're saying there's only one reality and this is it. Kyle Rittenhouse was only considered an active shooter if he was out there murdering people. He was not. He was shooting in self-defense, and each one of the instances is easily provable through video evidence. You don't even need to go through all this witness testimony. I've been screaming this for a year now. So the Georgetown law professor brings it up, even though they don't play the video for you. An MSNBC viewer would never even get to see this witness saying, I pointed my weapon at that kid before he shot me. They don't get to see that. They got to see the other nonsense that MSNBC wanted to present from the witness testimony. And then they mention it in passing from the professor. This is all mental manipulation in how they're presenting the facts. The framing has gotten so out of control that it just strikes me as an alternate reality. It's quite bizarre. Now, because MSNBC is never going to show you, I put the actual moment that this guy said what he said on stand. So this is what the MSNBC host calls that little thing the defense got him to admit. That little thing.
With your arms up in the air, he never fired, right?
Correct.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
So when your hands were up, nothing was happening. Then when you put your arm down and started advancing on him and pointed the weapon at him, it wasn't until you did those things that you were shot. Correct. So that's the, quote, little thing.
Well, in fact, he was right. Kyle Rittenhouse was an active shooter, and he already killed 2 people. What citizens are supposed to do in that situation is to call the police to alert authorities. This witness testified he put his hands in the air, but when he saw Mr. Rittenhouse re-rack his rifle, he was afraid for his life.
That's what the witness testified, but it's been proven that he didn't re-rack his rifle in a menacing manner.
The videotape is the star witness in this case, so the jurors will look at the videotape, they'll hear this testimony, and then they'll decide whether they believe this witness or whether they believe Mr. Rittenhouse.
Now, in my intro to you, I said that the judge instructed the jury to disregard Grosskreuz's description of the shooting of a protester as, quote, murder. Is that because murder is actually there's a legal definition of murder?
That's exactly right. So it's the jury who will decide whether Mr. Rittenhouse is a murderer based on the fact that he killed the first 2 victims in this case. This judge likes the limelight, and he's micromanaging this case. This is the same judge who did not allow the victims in this case to be described as victims, even though Mr. Rittenhouse killed 2 of them. And the witness who testified today had graphic testimony about how Mr. Rittenhouse blew the bicep off of this man's arm.
First of all, those are the same 2 issues. You can't say that the protester was murdered, and you can't call them victims for the same legal reason. So this news host just says that, and then the Georgetown law professor says it right back to him in a different way. Oh, this judge wouldn't let them do this either, but it's really the same thing. They're trying to create these multiple things that the judge has done that shows that he is somehow biased, and in reality, it's the same situation. He won't allow them to call it murder for the same reason he won't allow people to call them victims. It is not rocket science here. What they're doing is manipulating. And then once again, they refer to the only hyperbolic part of the testimony. It blew his bicep right off. Like, look at the emphasis here. Of all the things these people could be talking about.
Had graphic testimony about how Mr. Rittenhouse blew the bicep off of this man's arm when he shot him.
Let's talk more about this judge, because I'm following loosely this trial, but everything I hear about this judge just sort of has planted the seed in my head that this trial is, sorry to use the word, rigged.
And here you just have it outright. Why would they hide it? Why would they hide it? And on top of that, you have to understand that these news anchors, these actors, they develop a connection with their audience. And so when they tell their audience, I feel like there's a seed planted in my head, I feel like this trial is rigged, then that's how their audience is going to feel. There is no presentation of facts whatsoever, only a presentation of emotion.
The instructions of the judge is making it pretty much impossible for the jury to actually consider all the facts and come up with a verdict where justice will be served. Or am I way out there in what I just said?
Not at all, Jonathan. I understand your concerns. Remember, this judge also ruled that the victims could be referred to as looters, arsonists, and rioters if there's evidence that is presented that they did those things.
So he ruled that if there's evidence that they did those things, that they could be called those things. Oh my God.
So far, no evidence at all. Mr. Grosskreutz was a trained EMT officer there to offer medical aid.
No, he was not a trained EMT officer. He was an EMT officer in training.
Rittenhouse's first victim wasn't a protester. He was a man who just been released from a psychiatric hospital who seemed to be having a mental health crisis. And so,
yeah, let's talk about all the other things that man was, and let's talk about why did he leave the mental institution and head down to the riots?
When the judge allows these victims to be described as criminals, that certainly calls into question his judgment, if not his bias.
And that's the coverage. It is some of the most outrageous propaganda I've seen in a very long time. And it's no wonder that the situations like the Nicholas Sandmann's situation and the Jesse Smollett situation and all of the others, it's no wonder that they keep happening, because the news media is outright lying. They're framing and lying, and they're doing it intentionally to manipulate a sect of people in the country who are just plugged in and they're not capable of being unplugged. Now, they did their best to frame this judge in the most horrible light. And the judge has like these little clips where he's yelling at the prosecution. Well, I'm going to explain to you the couple of things that happened in this day that got the judge all riled up. And we're going to go over the footage. Unlike what MSNBC does, just framing him as some kind of low-key racist who is ruining the case, and when the jury comes back with the wrong verdict, quote, it'll be the judge's fault because they weren't able to come to the right conclusion because of the judge. Okay, so that's what was just presented. Let's instead go through and figure out why the judge was yelling at the prosecutor. Earlier in the day, and what the judge got really fired up about was when he was talking about how the prosecutor had commented on Rittenhouse's right to remain silent. See, Rittenhouse has a constitutionally protected right to not talk about what happened, and he hadn't until he was put on the stand. Now, this is a sacred cow, so to say, in the justice system. It's something that even people who just watch crime dramas know that is a sacred thing and it's to be protected. And so when the lawyer earlier in the day tried to use it against Rittenhouse, it was just such a flagrant foul that it rightly made the judge and the defense wonder, is he trying to throw the case? And they don't show you in the little clip him questioning Rittenhouse's constitutionally protected right not to say what he doesn't want to say. So I'll play it for you now. This is him stepping out of line for the first time this day.
Since August 25th, 2020, this is the first time that you have told your story.
Sustained.
Since August 25th, 2020, you've had the benefit of watching countless videos of your actions that night, correct? You've also had the opportunity to listen to the testimony of all 30-some witnesses that have testified in this trial so far, correct?
Yes.
And after all of that, now you are telling us your side of the story, correct?
Correct.
I am making the point that after hearing everything in the case, now he's tailoring his story to what has already been introduced.
The problem is, this is a grave constitutional violation for you to talk about the defendant's silence. And that is, and you're right. You're right on the borderline, and you may be over, but it better stop.
Understood.
It may be over, but you better stop. As in, you may have already caused a mistrial. That's what the judge is saying here. And so earlier in the day, this Yahoo tries this move. So let's go to the other video.
You have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
You have previously indicated that you wish you had your AR-15 to protect somebody else's property. Okay. The judge had already ruled that he was not allowed to bring up these prior statements. Kyle Rittenhouse had supposedly made statements weeks prior suggesting only dealing with things that happened that he wished he had his AR so that he could go protect property. Now, they're not relevant to what happened that night in any way, shape, or form. And the prosecutor is trying to use case law to justify this that is in the moments before the criminal act happens, right? Not 2 weeks prior when some guy is talking to a friend about something that he may or may not have wished for, and then 2 weeks later something happens. That's not the case. That's not the way the case law worked. The case law was talking about threats that were made in the moments leading up to the incident. And so the judge ruled that you cannot bring this up. You can't bring this up, okay? But he ruled I might look at it again later and change my judgment. So he left the door open for himself, the judge, to revisit this issue. So that's where we're at when this prosecutor then does exactly what he was told not to do.
I'm going to ask you to go into the library again for a moment, please.
The judge has to kick the jury back out again. At this moment, the prosecutor has to know he's in trouble. It's like getting called to the principal's office. And he already knows what he did wrong. That's the thing. So this guy, it's like, is he intentionally trying to throw the match? Or is he just this horrible? And I don't know. But the way it's being framed in the MSNBC world is that this is the judge's crazy, not this completely inept or intentionally misguided prosecutor.
Please don't talk about the case.
Your Honor, Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions.
The defense attorney here is saying you've already ruled on this matter, and he's either forgotten that you ruled on it or he's intentionally trying to throw the match and get a mistrial because he's already asking the questions that you told him he wasn't allowed to ask.
Ask the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney, and he knows better.
Mr. Binger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
For me, not for you.
So now you understand why the judge snapped, because this guy is trying to say this was the subject of a previous motion, true, and it was already ruled on, true, and you left the door open for me to come in and say what I wanted to say. Absolutely untrue. And he knows it. The prosecutor knows it. The prosecutor knows that the judge left it open for him to rule on again if he changed his mind, if there was new evidence that presented. And in that case, if new evidence came out, say during the testimony of one of the witnesses, and the prosecutor thought that it would be more relevant now and the judge should look at his ruling again, then the prosecutor would go up to the bench. Your Honor, may I approach the bench? I think on this previous issue that you had ruled that I couldn't say this and this, that has now changed and you left the door open to revisit this in case something like this happened. The judge makes another ruling. That's the way it goes down. You don't have to be a lawyer to understand that. So the fact that he's saying you left the door open so I stepped through, of course that's going to infuriate the judge because he knows you know better than to say that.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
their motion.
We have not filed any
me.
motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury. I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that.
Because what he wants to say is it leaves the door open. It gives the defense a cause to request a mistrial without prejudice. That's what the judge doesn't want to say out loud, but that's 100% what the prosecutor is putting this case in danger of.
What you're up to?
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion.
Because he wasn't. He was talking about it. And this is 2 weeks prior. And the judge is like, no, he wasn't actually using it. He was just mentioning something to somebody else, if that actually happened. And now the judge is like, wait a minute, I'm not the defense attorney. I'm not going to argue with you about this. I've already ruled.
Yeah, that's absolutely untrue. No. Your arguments of record, my comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot.
See, the thing that the prosecutor's doing here that's messing things up is that now he's going to try and relitigate this ruling again by saying, well, there are things now that have come up since then that I feel like open the door to this. And the judge just 2 seconds earlier said there's not been anything that has happened to change my mind. So now the lawyer wants to re-argue this, and the judge is going to tell him no. But just the insanity, the audacity of this guy is just beyond the pale.
Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days.
To impeach a witness, it just means to discredit them, to prove that they lied.
Prior, involving the same gun, where he is threatening to use that gun to protect property. It goes.
He had the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense of the case is. May I
respond to what you just said, Your Honor? I'd like to respond to what you just said.
Slow down, please.
I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay.
This guy is just one of those douchey guys that is just an asshole and doesn't know it, and like people cannot stand him. Like even his own family hates him. Like he's just one of those assholes, you know?
Believe that there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out. So, to your point, Your Honor, you're arguing that this August 10th incident one aspect of why you don't believe it's relevant is the defendant didn't have the gun with him. This case is about someone who didn't have a weapon, and yet the jury is being told because of those threats.
So the lawyer's position is that Kyle Rittenhouse's previous statements are not being allowed because they were 2 weeks prior and he didn't have the weapon with him. Also, the main point being they were 2 weeks prior, and that the guy who Kyle Rittenhouse shot, the first one, also was making threats to kill somebody but didn't have a weapon on him either, but it was not 2 weeks prior. So he's trying to make this comparison so that he can introduce this argument, and the judge has already told him, no, you can't because it's 2 weeks ago and he didn't have his firearm with him. And he's trying to say it's the same thing, that the guy that was threatening Kyle Rittenhouse right before the incident happened, it's the same. It's not.
Means the defendant has to defend himself. So, with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions. I am attempting, with the defendant, to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling because I
probably should have? I misunderstood? See, this is not an apology.
Your ruling was if the evidence in this case made that more relevant, you would admit it or at least consider it an admittance. I believe, based on the evidence that we've heard, and more specifically exactly what the defendant said earlier about admitting pointing a gun at someone who was merely jumping or sitting on a car, that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that. But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call
his statements to, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior reason he doesn't like guns. And I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop. And he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings.
So why? Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
And what the judge is dancing around there, again, is that he's curious, are you trying to throw this trial? And he has every right to be suspicious of it. So there is your irrational, out of control, what did the guy say? Judge who likes the limelight and is micromanaging the trial. So there you go. I hope I was able to shed a little light on it. I'll catch you guys next time. Oh, also, guys, I don't talk about donation an awful lot, but if you enjoy somebody's work, throw them some donations, guys, because all of my videos are demonetized. I've been denied the YouTube partnership program. I do this all for free, except for the donations that I get, and I have some regulars, and you guys are very near and dear to my heart. I appreciate everything you guys do for me, but got to support the people that you enjoy, not even talking about myself particularly, but if you respect the work that people put in and you enjoy their content, try to support them. It's not easy out there. Anyways, guys, like, share, subscribe to the channel. Catch y'all next time. Peace.